two witnesses for coming to the committee today to discuss the devolution settlement in the context of leaving the European Union, and particularly Clause 11 of the EU Withdrawal Bill. Can I first ask you to identify yourselves for the record?
Professor Nicola McEwan, and Professor of Territorial Politics at the University of Edinburgh, Associate Director of the Centre on Constitutional Change, and the Research Leader for the UK in a Changing Europe. And I have to acknowledge all of those. Sorry.
Michael Carpenter. I was Speaker's Counsel for 8 years until last year when I retired. And I held posts in the European Commission and in Government Service, and indeed the House Service before that.
Well, thank you for being with us. We will ask fairly robust and short questions, and if you could keep your answers relatively crisp as well, that would be very helpful, and I might pull people up if they are going on a bit long. In the sixth report of the 2016-17 session, we produced a report called The Future of the Union, Part 2, Interinstitutional Relations in the UK, and we concluded that the existing interinstitutional mechanism and arrangements are not sufficiently robust or effective. And now with these powers coming back from the EU, which effectively create overlapping competencies between each of the Westminster Parliament and each of the devolved parliaments, what in your view needs to change in order to make intergovernmental and interparliamentary relations effective?
Okay, shall I? I think there are issues around process and there are issues around practice. With respect to process, it should give us some cause for concern that the one forum of the Joint Ministerial Committee that has been considered, relatively speaking, to work reasonably well to the satisfaction of all parties is the JMC Europe. Now that's the one that will soon become redundant. And so that begs the question as to what will then replace it. I think there are a number of process innovations that can be made. I think one of the reasons why the Joint Ministerial Committee Europe worked was partly because the timetable was in a sense dictated by the timetable of the European Council, but also because of the external factor having an effect or having that sort of influence on the overlapping competences, as you mentioned, Mr. Chairman, and so it necessitated a degree of communication and cooperation between the different levels. And I think we can think of post-Brexit similar things that may necessitate that type of cooperation. One is other external relations, in particular trade, another is the internal domestic sphere around the operation of what we are coming to term the UK single market or internal market. So those are two separate forums that I can see don't exist at the moment, but may be particularly useful in a post-Brexit scenario. But that's just process. Culture, I think, also matters.
Should I comment on the culture?
Yeah.
I mean, my experience is getting a bit old now, but as a lawyer, one grows up with the idea of close cooperation with Northern Ireland, Scotland, to an extent Wales, because they have separate legal systems. I mean, it's unique, I think, in the European Union. So this is what you grow up with, and certainly during my time in the Lord Chancellor's Department and in the Attorney's Office, close cooperation with particularly with the Scottish Courts Administration, as it then was the order of the day. Indeed, when I was taking part in negotiations on international agreements, particularly for enforcement of judgments on civil jurisdiction, I would actually sometimes speak for Scotland, and Scotland would sometimes speak for us. And it was just sort of, we worked hand in glove. So there's a very strong culture of cooperation. I think, and this may be sort of unwelcome, that whenever you introduce legislation, the culture in a way gets damaged, the culture of cooperation, because then people look to their rights and it doesn't strike me as working quite so well. As far as interparliamentary cooperation is concerned, I think on the legal side I would say that is rather good, because we have a regular sort of conference of parliamentary legal advisors of all the parts of the United Kingdom and the Republic of Ireland. We meet every year, and there is a lot of interchange between the year. There's an informal network where we help each other out with particular problems, iron out any difficulties. So that culture is, I think, alive and thriving as far as that is concerned. But I do think the culture side is very important. I think people have to.
But how is the culture adapted to the fact that there are now very visible political differences representing different elected governments and different elected parliamentarians in different parts of the United Kingdom? So what you're talking about, Mr. Carpenter, was very below the political radar. We're now dealing with open political conflict, which is very visible, and where people are seen to win and lose, and want to be seen to win and do not want to be seen to lose, and we don't seem to have any institutional frameworks for dealing with that.
Well, it's a fair point, but it's probably a bit beyond my pay grade as a former civil servant to resolve.
Professor McEwan was nodding.
Political scientist, maybe. I think what we see from looking beyond the UK to where this is more commonly, where intergovernmental processes are more commonly practiced, is that sometimes you can take the heat out of situations when you have a purpose and a focus, and often a sectional focus to intergovernmental proceedings. So if they are task-orientated, then that can help to ease some of those more politically contentious battles, if you like. But you also can't get away from them. So part of the reason why we have devolution in the first place is because there was a concession to different preferences, perhaps different interests, and there are different mandates. And I think part of the culture that I was referring to is just having perhaps some empathy and respect for the different mandates that the governments, and I'm not just talking about the devolved governments here, but I think it works both ways, that governments are operating to. If I can add one final point on culture, which is not just about the sort of the politics of this, but I think there are some procedural things that matter too. So a lot of the frustration I have found when speaking to officials within the devolved governments is around the organisational culture of intergovernmental relations. So the late circulation of papers, the not giving enough time for them to consult with the variety of different departments across their administrations that may be implicated. So that seems to me to be a relatively apolitical and relatively easy fix that can help at least facilitate good communication and cooperation.
So how do you promote that institutionally? I mean, the JMC met about 3 or 4 times over the period since the referendum, formally, and very sporadically. I mean, what do we learn from other devolved systems of government, and indeed from the EU itself, about how to handle shared competencies and disagreements between the centre and the constituent parts?
One thing we may learn is that schedules can be useful. I think ministers in the UK government and the devolved government seem to me to be unwilling to sort of stick to a set schedule just in case they're meeting without anything clearly to discuss. But a schedule can help to organise minds, it can help to organise activity. Obviously, in the EU context, it is dictated by a pre-existing schedule anyway. Maybe that would make sense within the context of negotiating trade agreements, for example. I think early engagement between the UK government and the devolved governments can also help to avoid difficulties arising in the future. In the example I'm thinking of here is when the EU and Canada were engaged in the lengthy negotiations over CETA. The provinces were involved in those negotiations in part to ensure that whatever was agreed at with the EU could be implemented within the Canadian Federation. And so we don't have a federation, of course, but there may be issues that can be addressed early on in the process that might also take the heat out of things.
So to what extent should the scheduling of institutional meetings be actually laid down in statute or expressed somewhere in statute so that these meetings actually happen?
Yeah, I've been asked this quite a few times, and I don't have a very strong view one way or the other. I'm instinctively wary of laying down procedural things in statute, although I'll probably contradict myself later on. In part because these are processes that are evolving, that need to evolve and need to adapt to what remain to be very uncertain circumstances in which we will find ourselves as the UK exit the European Union. So I suppose it would depend on what was said in statute. You wouldn't want it to be prescriptive because you would want the processes to be able to adapt to experiences and lessons learned by all of the parties. Perhaps what would be, certainly from the perspective of the devolved governments, what I think may help to facilitate and necessitate intergovernmental cooperation is if the consent, if their consent for certain issues is written down in statute, then that's not anything about the processes themselves, but it necessitates that process to take place.
Thank you. Mr. Flynn.
I think we appreciate that we're asking you questions which there are no answers. Could I ask you, I'll try and make the question neutral, what opportunities and dangers does the UK's possible departure from the EU present for the potential reform and degradation of intergovernment relations within the UK? Is it going to make the four nations come closer together, or is it going to make them be more divided, or both?
It's an impossible question. I'm just hopeful. I mean, we have had a union for hundreds of years, which has withstood considerable shocks before. So I'm confident actually that we can pull together. But that's all I can say. I mean, my opinion is worth no more than anybody else's.
I think UK is a plurinational state, and we have a situation just now where, to some extent, the different nations are pulling in different directions on the issue of Brexit. I think Brexit creates opportunities in that because of the repatriation of competences, whatever model of Brexit we turn out to have, there will be new interdependencies, new jagged edges, if you like, between what is reserved and what is devolved, and that will necessitate closer cooperation between the governments if this thing is going to work. Now, that also requires commitment, a willingness to engage, a willingness to compromise on different sides. I think that willingness is there, but the different governments are responding to different political pressures that can sometimes themselves pull them in different directions. So lots of challenges, I think, with Brexit, some opportunities too.
The process of devolution from the British government has been one that's seen as grudgingly given, and because, like most bodies, the British government is power retentive. Could you see that the process that we have at the moment is treated with great suspicion by the devolved bodies, because they see it as a power grab, because in the legislation there's guarantees that power will be taken away, possibly for a short time, but there are no guarantees that power will be increased or retained.
I think that's certainly their concern. I'm not privy to the motivations underpinning those particular provisions within the bill. It may be, as you suggested, about seeking to retain authority. If it is that, I think it's also with an eye to being able to negotiate first an agreement with the European Union, but also the other trade agreements that will come afterwards. But that's certainly their concern. Of course, they are working more closely together now. We gather within the resurrected Joint Ministerial Committee EU negotiations, where they are exploring more deeply the intersection between EU competence and devolved competence and exploring the issue of common frameworks. I'm sure we'll come to talk about those. But I think there are concerns. I think they're right to have some concerns, and I think there's an opportunity for the UK government to make a gesture that could help to inspire trust in the process and in the commitments that they have made verbally to devolve further powers later on.
I mean, could you think that the Welsh Government would have trust in the central government after the experience of, I believe it was 5 bills passed by the Welsh Government, which were then challenged by the Attorney General in the High Court? So effectively, Wales wasn't governed, or Welsh law wasn't governed by democratically elected representatives, it was governed by judges. And in the basis of that, and every other obstacle that's been placed in the way of devolution, which took 3 referendums, which we hope BrExit will take at least 3 referendums, we've already settled, but on the basis of the bad blood of the past, don't you think that the devolved assemblies and governments are right to be suspicious of, in the belief that they suspect national governments will bear gifts?
I mean, in a sense, it's a matter of political judgment. I think that they have concerns that are valid concerns in light of some of the experiences that you referred to. I also, while I think the UK government is sincere in its efforts to negotiate common frameworks, one of the problems with Clause 11 as it stands is that it doesn't really give the devolved governments much leverage in the negotiation of those frameworks, because it leaves a situation where if there is no agreement, if there is stalemate or a failure to agree, then Clause 11 as it stands would result in the retention of authority by this Parliament.
A final point, a brief one. Do you think that these matters have the only chance of being resolved is by horse trading between the national government and the devolved assemblies, rather than having recommendations from select committees? I mean, I see there is a huge amount of work on select committees now. I sit on 3, and they're all totally obsessed with BrExit. And there are others whose job is to be involved only with BrExit. But you see this excessive amount of attention being given to something that may not happen to be a blind alley, and that the ultimate deal must be done directly between the government and the devolved bodies.
I hope it's not a blind alley, and I don't think it's excessive. I think it's appropriate that select committees in this Parliament and in the devolved legislatures are engaging with this issue. They are talking to those with expertise, talking to stakeholders who would be affected by this, and I think that's absolutely the appropriate way to address this, by giving the topic scrutiny. And it's unfortunate that intergovernmental processes on this occasion and in all others lack the kind of transparency that would enable us to engage more directly and to know the nature of the discussions that are taking place. I think there's there's a space for private discussion between governments and a space for negotiation between governments. But when I did a study a couple of years ago looking at parliamentary scrutiny and oversight of intergovernmental relations in lots of different countries, and while it was certainly the case that the executive arm of government dominated the processes and there was a lack of transparency everywhere, nowhere was that as evident as it is in the United Kingdom.
Your answer is a very interesting one, but it does throw up another question, is that we've learned just today that the government is going to deny transparency in the reports that they've published, and they're redacting them heavily, so we're told. I mean, isn't it true that we can't have an open discussion? But it's part of the answer that Rosie... Yes, I did, but
other people must be given a chance.
I haven't recalled that the chairman, of course, has a very partial position in this and was an enthusiastic campaigner for Brexit at the time.
Mr. Fysh,
and which should be borne in mind.
Order.
What involvement have the devolved administrations had in helping develop EU common policies up until this point, and has that been done via the UK's input into the EU or separately?
Primarily via the UK's input. So the JMC Europe that I mentioned previously is the primary forum through which the devolved governments have had the opportunity to shape the UK's negotiating position prior to issues being discussed and debated and negotiated within the Council. Of course, they will have relations with parliamentarians as well. The European Parliament has become increasingly important in the policy-making process in the EU. But I think primarily it's an indirect route. Now, how effective that has been is difficult to evaluate, in part because of the transparency issues we've just been discussing, but also because there has, within that process, and here's one of the frustrations, which is why I said there was relative satisfaction, in a lack of a feedback loop. So there's lots of input, but unless the devolved governments are present in the room as the negotiations are going on, they don't necessarily know whether their input is having an effect and how much influence actually they've been able to have with that process.
Because I asked the question because I thought that you made an interesting point about the opportunity for us as we go forward to develop new ways, make an offer of some kind to make the devolved administrations more involved in the thoughts about what common policies should be. And you know, my own point of view is that it is fairly clear, actually, that you know we have the deference to EU law arose from the commitments that the UK was making to the EU in that instance, and as it comes back into retained EU law, that's entirely reasonable that it should be under the UK control, because it is the UK that then will need to make a deal with the EU or with any other party. What on a practical level do you think that can be done to involve more devolved administrations in that process of setting those UK common policies?
Before I answer that, I just want to kind of maybe take issue slightly with one thing. The UK is the member state, not the UK government. And the UK government has a responsibility to represent the whole of the UK, but the UK is a multi-level state. And I think recognition of that in the internal processes would be helpful and constructive here. The UK is also extremely unusual in the extent to which it's the distribution of power is asymmetric, and that the absence of devolution within England is a barrier to developing processes of co-decision that you sometimes see in federal states or more uniformly decentralised states. Nonetheless, I think there is still an opportunity to engage with the devolved governments not just at the point of coming to implement an agreement, but at negotiating, at formulating an agreement to make it what the Prime Minister had said initially after appointed. She wanted a genuinely UK approach to Brexit, and she raised the expectations that that's what the GMC-EN would achieve. It didn't do that. So having raised those expectations, the devolved governments were left rather frustrated and disappointed by it. But the process that we're in now seems to be going some way towards that. So there is, within the GMC-EN at the moment, an active process to try to work collaboratively to develop, first of all, a process for agreeing common frameworks, and then later what the content of those frameworks may be. So we will see.
Cheryl Gillan.
I'm just picking up on what you said, because I mean we know the JMC is not a particularly well-loved organisation, and certainly doesn't provide the mechanism for correct dialogue between the devolveds and the UK government. And when I had some influence on these matters, I was quite keen on trying to get a forum where we had MPs and AMs or MSPs together to almost look at certain specific policy areas together, which was the natural sequitur to the Cabinet subcommittee that I set up, but then withered on the vine because the Liberal Democrats in coalition didn't want it, whereby we had a minister in each department that was responsible for looking at devolved matters and areas within those departments. Do you think it would be worth looking at what mechanisms and what we could set up whereby, say, AMs and MPs sit together looking at home affairs issues or looking at agricultural issues together, and likewise with Scotland and with Northern Ireland, because we don't have any formal contacts between MPs and AMs and MSPs, and it just seems to me, if you're trying to engender trust, sorry I'm a bit long, but if you're trying to engender trust and good working, you must have the fora in which you can do it, and we just don't have it. There's JMC, not even having a Scottish Grand or a Welsh Grand Committee. Do we sit with AMs or MSPs? So,
well, I think there's certainly scope for trying to model something like that as we move forward, as a supplement to the activities that are already there, so long as you can build in, similar to the executive level, the appreciation and the respect for different mandates, different interests, different perspectives. And it may well be that if we can move forward towards a more organised system of intergovernmental relations and forums, then it may make sense to help enhance the scrutiny of those processes, to have something at the parliamentary level as well. I know that there have been informal links between the committees, particularly those examining Brexit, but you know, there's certainly a case I would see to have a more formal, more organised kind of arrangement as a supplement to what's going on.
Moving on. David Jones.
Professor McEwan, in the first of your two papers, you noted that the plurinational character of the state, especially within the current context of competitive nation building and contested constitutional politics, shapes the motivations and trust of the actors involved. Could you expand on what you mean by competitive nation building and contested constitutional politics, please?
Yes. Trying to think of which paper you're referring to.
Sorry,
no.
Still better together.
Ah, this one. Okay, yes. So, I mean, that was looking at the UK in the context of, you know, comparing it with other systems. And I think what we see in the UK, we also see to some extent in Canada and in Spain, other states that are plurinational, where sometimes the solidarity, the commitment to living together in one country, in one state, can't be taken for granted, particularly when you have governments that wish to see a different outcome, that wish to see that consider that they are representing a distinctive nation, that they would rather like to have greater authority, greater self-government, and in the case of the SNP government, ultimately independence. And that influences the approach, the assertiveness and the approach taken within the intergovernmental arena. So, for example, in the case of the BrExit referendum, legally, of course, it was a UK-wide referendum. The mandate was the mandate of the UK as a whole, but when you have the context where a nation within the United Kingdom has voted a different way, if you look quite closely at the response of the First Minister, Nicola Sturgeon, to that fact, she was seeing that as a different national preference that she in some ways wanted to and also felt compelled to advance a distinctive interest within that process. Now, I think the UK, because the multinational character of the UK has broadly been recognised by successive governments over the years in ways that hasn't necessarily been the case in Spain or in Canada, then we can sometimes get away from the sort of nationalist competition that you have sometimes seen in intergovernmental relations elsewhere. My concern just now is that we have, in a sense, two different self-determination projects, and the language of self-determination has been used by the Prime Minister in the context of Brexit, as including in the Article 50 letter, for example, in the Brexit White Paper, to talk about Brexit as being the self-determination as we see it of the people of this country. Well, that rather depends on how you characterise the people, and that obscures the plurinational character of this state and all of its divergences.
Are these tensions inevitable in the case of devolution settlements, which are founded upon plurinational considerations? I mean, you mentioned earlier on the CETA arrangement. I remember waiting for a very long time in a conference call in Luxembourg for a telephone call from Wallonia, which never actually arrived. And of course, as you know, in that particular case, the entire treaty was very nearly thwarted as a consequence of the refusal of the Walloons to consent. So, is this an inevitability, or can these problems be overcome?
Differences, I think, are an inevitability at some point. It doesn't mean that if you have different governments with different mandates, you will always have different policy positions. That's not the case, obviously. But sometimes it will be. And the point of a multi-level system is that that we can all respect those differences and the different interests and mandates at play. I wouldn't necessarily see the need for securing consent from a regional government within a multi-level state as a problem or as a sign of tension. It's a sign of a need for compromise, and that may have been avoided if there had been more engagement with the regional government earlier on. Of course, Belgium is somewhat unique in the extent to which the regional governments are sovereign for external relations in their areas of jurisdiction. We don't have that in this country.
You mentioned respect. Does respect have to move in both directions?
Absolutely it does, yes.
So in the case of a UK-wide referendum, should the Scottish Government have respected the decision of the United Kingdom?
I think they have. They've said that Brexit will happen and that they respect that is the outcome, but that doesn't mean that they ignore the decision that was made in Scotland.
In terms of future intergovernmental relationships, what do you think could be done to improve matters?
Well, I've already mentioned a few different things around the different types of processes that we might have and the practices and the culture. I would be, I suppose, a little bit wary of moving towards a more formal structure of co-decision. I don't think that fits very well with our political culture, and it wouldn't respect the sovereignty of Parliament, but there may be scope for using intergovernmental processes to come to non-binding agreements that may be binding in honour, or to have a more task-orientated nature to intergovernmental processes. They've got to be worthwhile for all of the governments at play. That was the problem with the forum that we haven't talked about yet, the Joint Ministerial Committee Domestic, which was set up after 2007, I believe, which was intended to look at sort of the non-EU aspect of intergovernmental relations, and it fell into abeyance, really, because there wasn't really a purpose to it from the perspective of all the parties involved. So that's to be a task, a set of tasks, or something that they can work towards that make it worth everybody's while.
You acknowledge that co-decision making is probably not an option. How do you proceed, therefore, in a case where it's such as, for example, in the case of our present discussion, Clause 11, there is disagreement between the United Kingdom government and at least two of the devolved administrations. They're actually calling for things to be agreed. But if things can't be agreed, who actually makes the decision?
What I meant by co-decision was binding decisions within those forums. So that doesn't mean that you can't have agreement and accord, which I think is also what's being called for.
But forgive me if I could just interrupt at that point. If it proves impossible for agreement to be achieved,
well, that is the perennial issue. Yes.
How then do you move forward?
I mean, I think that is one of the biggest issues that we haven't really confronted very well yet, is what happens if there is no agreement? What is the process for dispute resolution? There is within the GMC a dispute resolution process and prevention, which is a very important aspect of it. I personally would like to see not so much a role for independent arbitration that you get in some countries, but a role for independent investigation, if you like, a sort of, some sort of body that can look at the evidence and then put forward its thoughts on the nature of the dispute. But ultimately, these are matters of politics, and disagreements will have political consequences that will ultimately be for parliaments and electorates to determine. But if I could just add one thing, part of the problem that we have just now, I think, is a lack of common understanding of the issues at stake. So I think, going back to perhaps something that Mr. Flynn said earlier, but I think the UK government thinks that it's respecting the devolution settlement with Clause 11, and the devolved governments don't think that they're respecting the devolution settlement. But we have here two different perspectives and understandings of what the devolution settlement is. And I think unless and until we have a deeper understanding and common language around the issues that we're talking about, then it may be difficult in practice to get that kind of agreement.
You mentioned in the same paper the constitutional hierarchy. Doesn't that hierarchy inevitably mean that in the case of dispute which is incapable of resolution, then ultimately it will fall to the United Kingdom government to decide what the outcome of that dispute should be? I mean, isn't that the reality of politics?
Well, constitutionally, it's so. If you're talking about the outcome of this process and the possibility of a lack of consent given from the devolved legislatures, first and foremost, that would be a matter for this Parliament to determine whether or not that mattered. Constitutionally, absolutely, you're right. There is a constitutional hierarchy in the nature of the relationship that, legally speaking, would mean that it would be a matter for the UK government, the UK Parliament, to determine what happens next. But those determinations may have political consequences, and that would be part of the strategic calculation, I guess.
There will inevitably be resentment on the part of the devolved bodies.
If they're ignored, or if their concerns are
Well, if they feel that they've been ignored, or
if they feel that they are being ignored, or if they feel that their concerns are not being recognised, then I have no doubt that there would be resentment. The question is whether that would have any lasting repercussions, ultimately lasting repercussions among the public, and I am less certain about that, given all of the complexities and certainly in Scotland the constitutional fatigue that has set in.
Thank you. Ronnie Cowan, briefly.
Isn't that exactly what the problem is? The UK government go into these negotiations over Clause 11 knowing that at the end of the day they don't have to do anything because ultimately the power will fall to the UK government.
I'm not privy to the motivations of the different actors involved, but I do think that so long as Clause 11 remains as drafted, that it is a barrier to securing agreement to the mutual satisfaction of all the different parties.
But it could be one of the explanations as to why things are moving so slowly. There's no one's lit a fire under the UK government and you have to make this work.
I think part of the reason why it's moving slowly is because it's a huge task. And I think that's part of the issue of why we're here in the first place. I think whatever were the other broader political motivations, one of the motivations around the Withdrawal Bill and the devolution aspects to it may have been about sequencing and ensuring flexibility. For me, it was almost as if there may have been a sense within Whitehall of, oh my God, Brexit is such an enormous task, we'll deal with the devolution bits later. But politics doesn't really work like that. And I think that, they will have to go in tandem.
Thank you. Very interesting. Moving on, Kelvin Hopkins.
Thank you. My question is a very open question, and you touched on it already. But I'd like to ask both of you, what more do you think is required in order to build and develop trust and mutual respect between the governments and legislators in the United Kingdom?
Well, one idea that occurs to me is, as a young civil servant, the character of the department was really determined by the Permanent Secretary. And this is why, certainly in my experience, the reports of the Parliamentary Commission for Administration, for example, were absolute top importance. And I think one possible thing is to have some sort of conference between permanent secretaries of the UK government and of the devolved governments, just regular meetings. I know they have their Wednesday morning meetings in the UK, but this sort of thing to generate a climate of mutual respect, I think, and the Italians say a fish rots from the head downwards, but I also think goodness can flow downwards from the head if there is leadership leading by what Lord Butler, I think, once called precept and example. I think that could certainly help and break down the tribalism that otherwise arises.
I agree with that. I mean, you can develop all the processes in the world, but ultimately personality of the Permanent Secretary, but also of the ministers involved, will have a heavy influence over the dynamics of intergovernmental relations. We've seen that in the UK, we see that elsewhere too. One of the things that can be done to instill trust is to accept some of the amendments that have been tabled jointly by the Welsh Government and the Scottish Government. I think recognition of the extent of cooperation between governments with different parties, different mandates, different visions of the future, I think is a sign of the shared frustration that they feel. Some of the other things I've already mentioned around developing a shared understanding and common language around issues like the devolution settlement, like common framework, like the internal market. As I think people mean different things by these things when they are talking about them. And I was struck by that in reading the statement of principles that the GMCEN issued at its last meeting in October, I think that was a positive statement, a positive declaration of a willingness to cooperate and work together. But it will only go so far if when you have a list of principles that actually you mean quite different things by the same terminology. So I think first principles would be to develop that shared understanding.
Yeah, Professor McEwan, in your written evidence to the committee, you sort of recommend or seem to support Professor Alan Page's approach and as a way forward. We might examine that later on, but would you recommend that and suggest that we do move forward along those lines?
Yes, I would certainly like to see that explored. Absolutely acknowledge Professor Page's contribution here, and I've, since talking with him about it and looking at some of the evidence, thinking a little bit more about it, I think it would have to be, or would be more usefully applied if it were on the face of the bill, rather than in a memorandum of understanding. So some sort of standing still provision within the bill, perhaps as a replacement for Clause 11 as it's there just now. And that would be, in a way, a gesture, not just from the UK government, but from the devolved governments too, of a commitment and a reassurance to not rushing to create divergences that would erect some of the barriers to trade and mobility that seem to be part of the concern underpinning Clause 11 in the first place.
Isn't a major problem that you can't please all the people all the time, and that within all these divisions of BrExit, devolution, independence of Scotland, there have been substantial minorities who have taken a different view. Unionism is still quite strong in Scotland. The Welsh devolution decision was taken by a very small majority, and so on. And that trying to satisfy everybody is quite difficult.
I think that's true, but I think my impression certainly is that there is quite a depth of feeling, certainly within Scotland, and when I spoke to the parliamentary committees within the National Assembly for Wales, also got this impression that this is not just a concern that's held by the governments of the day, but there is a broader feeling that the process of Brexit does create some challenges for the devolution settlements. So it's perhaps recognising that this is not just a purely partisan issue. Yes, that you can't please all of the people all of the time, but you can please some of them some of the time, and I think there's certainly scope for compromise here.
Yeah. And my last question really is, what has been the impact of the UK government's handling of the EU Withdrawal Bill on those relationships so far?
Speak your mind.
I'll let you answer that one first.
Well, I don't really have a view on the politics of it all. I mean, my whole career is trying to fix things, and I think this is a fixable problem. It has been blown up to a much more important question than it really is. I mean, if you look at the Professor Page analysis, with which I respectfully agree, the problem is really very, very small. It relates to agriculture, fisheries and environment. And you can take the view, just let it rip, don't do anything at all. That would please Scotland and Wales, would be less happy in the UK. Or you can have the existing provision, which is a sort of restatement of the restrictions imposed by EU law. Somewhere in between, I think there's a room for a middle position that doesn't do too much harm. Well, let's say both sides are equally unhappy, and if you have that, you have a deal.
Professor McEwan?
Yeah, I mean, I think the situation that we're in just now is quite positive. There's time within Parliament to debate all of these issues at committee stage. There is now engagement with the devolved governments over common frameworks and, as far as I'm aware, over the amendments too, and that's all very positive. I think, to answer your question directly, I think it's unfortunate that that depth of engagement wasn't evident earlier on in the process, both in the run-up to the triggering of Article 50, where there was engagement, but there wasn't frank discussion and common understanding, I guess, and over the drafting of the bill and the white paper that preceded it. So that was then. We're in a different situation now, so I think there's opportunity to make that right.
Just a brief comment at the end of my questions, but early on in the discussion this morning, you talked about early engagement. Should the government and all sides have seen some of these problems coming before they happened?
Yes.
Can I just press Mr. Carpenter? I mean, you mentioned agriculture, fish and the environment. What about the regional and structural funds? The government has been talking about replacing them with a UK prosperity fund. To what extent is this also something that is amenable to a common framework approach from a legal point of view?
Well, I'm sure it is. On the narrow legal question, it is not a matter with which Clause 11 engages, because you're not talking about retained EU law as restraints on competence there, because if there are no, if there is no EU regional policy operating, there is there is nothing left. There is no limping competence. Of course, assistance to industries or firms or whatever in the devolved administrations could conceivably alter conditions of competition within the UK. It could do a bit like state aids, whatever, and you might want to have have an eye on that. But I think that's rather exaggerated, isn't it? I mean, the likelihood that Scotland or Northern Ireland or Wales would give such a massive subvention to domestic industries in such a way that it actually damages the
but state aid is a reserved matter anyway. So that's not in contention.
Quite.
Professor McEwan, we already have city deals that effectively are Westminster or Whitehall programmes affecting cities in devolved polities. How do you imagine that the replacement of the regional and structural funds from the European Union should be handled? What is it?
Well, with respect to city deals, obviously devolved governments are involved there too, and finance those initiatives as well. Good question. I don't have a full answer for you just now, but whatever it is, that is absolutely one area where I think that there should be cooperation and discussion between the devolved governments and the UK government. Finance, obviously, whether it's in structural funds or the bigger issue around agriculture, is obviously going to be extremely important, and is the one area that can be sure to create some intergovernmental tensions if you don't get it right. Just one thing on the I think it's a bit more than agriculture, fisheries and environment. Obviously we have, in relation to Scotland, the 111 powers that were listed. Actually, if you read through those, it's a bit of a mishmash of laws, regulations, programmes. I think there was even one database listed there. I hope that the deep dive exercise that the governments are engaged in just now will shed a bit more light on exactly where we are with the intersection of EU and devolved competence. The one thing I would add, though, is I think there also needs to be closer intergovernmental cooperation and communication on the new reserved matters that will impinge upon devolved competence. State aid, you mentioned already, but there's a whole host of repatriated powers that will, under the existing settlements, be reserved matters. Many, many more of those than will be devolved, whatever happens to Clause 11, but they will impinge upon other areas of devolved competence, whether it's things around employment law or the economy or markets, competition. all will have an impact, a direct impact on matters that are under the jurisdiction of the devolved governments and parliaments. And so there is very much a need, I think, for greater cooperation on those issues as well.
Thank you. Moving on, Cheryl Gillan.
Sandy.
Oh, I beg your pardon. Sandy, I beg your pardon.
Yeah, you've already mentioned the stumbling block of Clause 11 to the relationship between the UK government and the devolved administrations, but can you briefly outline what you think the main strengths and the weaknesses are in the actual bill for the reparation of powers? I mean, obviously with reference to clauses 10 and 11, but any other clauses as well, if you want.
Well, I think the main strength for the devolved governments and parliaments is the main strength for the UK government and parliament too, in that the main thrust of the bill is to ensure a degree of certainty and continuity by converting the acquis into domestic context, or the bits of it that are relevant. So that assurance of continuity is a positive that goes across the board. The question is, do you need Clause 11 for that? And I don't think you do. I think the continuity on exit day is secured by the other parts of the bill, and Clause 11 is about what comes next.
Scott.
I mean, I agree with what Professor McEwan said about the strengths, and we have to be realistic here. This is a massive operation. It seems to me that provisions to, as it were, hold the ring are the only practical way forward, given all the other things that have to be done. Whether the ring has been placed quite the right place in Clause 11, I think I've said before, it could be described as a bit of a steam hammer. Really, is that sort of block necessary, and is there room for some attenuation of this to deal with the matters that really would cause damage to the UK's internal market? Because that seems to be the real concern. I mean, so many commentators have made that point, Professor Page and Supreme Court, etc. And it seems to me one possible way forward is to amend Clause 11 so that modifications can be made so far as they don't seriously affect trade within the United Kingdom or the conditions of competition within the UK, so that you allow some leeway, but not a complete blanket ban. That seems to me to be sort of unnecessary. I think there are two extreme positions. One is get rid of Clause 11 altogether, I mean the particular restraints, or you have the existing clause. One is the big end and one is the little end, if I can quote Jonathan Swift. Somewhere in the middle there ought to be grounds for the two sides to meet, to allow the effective exercise of these competences, unless they actually damage the UK's internal market. And it seems to me that there ought to be a basis for some sort of compromise. Discussion of UK frameworks is obviously a good thing. The only thing is, if you don't have something in the bill, you're going to be vulnerable to third-party challenges to exercise of competence, as happened with Imperial Tobacco case and the recent Scots Whisky Association. So that would argue in favour of some sort of amendment on the face of the clause.
If I may add one more thing, one of the criticisms of the bill across the UK has been the scope of executive authority that it gives to the UK government, and that's not matched by the scope of executive authority that's given to the devolved governments. Their authority is much more constrained. However, the issues of a lack of parliamentary oversight that have been discussed in this House are amplified even more in the devolved legislatures, because the bill also extends the authority of UK ministers to amend through secondary legislation, potentially amend the devolution, the founding statutes for the devolution systems, the devolved parliaments, and without the consent of ministers or the consent of those legislatures involved. So I think, yes, there are absolutely legitimate concerns about parliamentary scrutiny here, but they're even more amplified, even greater for the devolved legislatures as well.
Professor McEwan, you appeared to suggest, I mean, I may have misunderstood, but you appeared to suggest earlier on that you thought that Clause 11 could just be dropped altogether. I mean, do you still believe that, and why do you believe that Mr. Carpenter thinks that this will give an intro to third party?
That's not my preference. My preference would be to, well, of all of the varieties of amendments and things that I have seen, the one I find most persuasive is Professor Page's recommendation of a standstill provision, similar to the standstill provisions that were within the Treaty of Rome originally. So obviously they were at a different, entirely different context, where you have this vision and a dream of creating an internal market, a common market. We're at a very different point where you have a great deal of market integration and you don't want to pull it apart. But nonetheless, you can have a provision which committed the government to not introducing anything that would jeopardise the arrangements that were in place until such time as agreement on common frameworks was secured, either until they agree that they don't need them at all, which is entirely possible in many of the areas, or until they agree on what the content of those common frameworks should be. So as a holding measure, it doesn't resolve the issue. It doesn't resolve the issue of the need for common frameworks, but it could provide, a standstill provision could provide some reassurance to all concerned that the devolved aren't going to rush off and dismantle the internal market, and that the UK government isn't going to retain all of the power. Crucially, a standstill arrangement would allow, constitutionally speaking, the powers to fall where they lie. So in other words, it would respect the devolution settlement as currently drafted within the founding statutes in Schedule 5 of the Scotland Act, and Schedule 7, I think it is, of the Government Rules Act.
And do you think that would work, Mr. Carpenter?
I don't know how I'd draft it, but then that probably wouldn't be my problem. I mean, I'm attracted by that idea. I think it's not bad, but I just wonder how practical it is, and whether there would actually be agreement to that. Because if there isn't agreement on an all-party basis, I mean, it won't fly, because the drafting of this could add quite a bit to the bill. And one's always mindful of what Lord Thring said: bills are made to pass as razors are made to sell. You can't practically add huge amounts on top of a bill that is already subject to considerable contention. So that's why I suggested this amendment, sort of sleight of hand amendment, to try and bring the two sides together, which is draftable and doesn't lead to lots of new institutions being created.
I think, to be fair to Professor Page, his suggestion was not to put it in the bill, but to have an intergovernmental agreement which would address that particular concern.
But I mean, to that extent, Clause 11, the government would argue, is a standstill provision. It simply maintains the notion that these powers were never de facto devolved, and they were held by the European Union, and they will now be held by the United Kingdom government pending whatever. But it's the lack of whatever which is causing the discomfort.
With respect, I don't think so. I think that goes back to my point about a different interpretation of what the standstill would be and what the situation that we're in now. So if you start As I have to say, I have for the last 2 decades I've taught this to students. If you start by trying to present an understanding of the devolution settlement as within the way in which powers are set out as reserved matters in the devolution legislation, at least with respect to Scotland, and by default everything else being devolved, but we have a good sense then of what is devolved, and it does include these areas that, yes, in practice, overlapped with EU competence, and so in practice there may not have been the same degree of scope to legislate within those areas, because for the Scottish Parliament, the National Assembly of Wales, just like for the UK Parliament.
But I mean, the Scotland Act also contains Section 50.
Yes, it does. Absolutely, it does.
I think it is.
It
which
does.
Reserves those powers.
Not reserves, no. The section that I think you're referring to is around the EU constraint. So the
obligation to
the
observe
obligation
EU
to
law.
observe. So an act of the Scottish Parliament is not law if it is not compatible with EU law, which is a consequence of the UK's membership of the European Union.
But it feels different, doesn't it? From a
it does.
reserve?
It very
I
much
understand.
feels different. I think that's right.
Mr. Fysh.
Yes. Is it not the case, though, that whether you're talking about a standstill until there is some agreement on these matters, or if one allows some modifications within the limits of potentially affecting things that are important to be common, to go back to your earlier point about the lack of common understanding between the parties that would be involved in making those decisions about what is important to these things and the politics of that it is not practical to have those things, and that Clause 11 as written is the only practical way forward.
I respectfully disagree. I mean, I think if you genuinely want to see a scenario where there is agreement between the governments, then I think Clause 11 is a barrier to that. Already within the system, there is an imbalance of power and authority, which is absolutely fine. That's the system that we have signed up to. That's the system as it stands. But there is nothing within the devolution legislation which prevents the UK Parliament from passing legislation in areas that are devolved. Of course, by convention they don't do that without consent, but so there is already a lot of authority. There will be even more authority as a result of BrExit, because a lot of the powers that concern the market, that concern the kinds of regulations that are necessary for external trade agreements or ensuring mobility, ensuring fair competition, and all of these single market issues are already going to be reserved matters anyway. And there is a backstop within the current devolution settlements that would enable the Secretaries of State to instruct the devolved parliaments, devolved governments I think it is, to make whatever changes were deemed necessary to ensure international obligations could be honoured and implemented. So there's a lot there already. And I think what Clause 11 does is, in a sense, take away what modest leverage the devolved governments have constitutionally from them. So it makes, that's why I'm saying I think it's a barrier to securing an agreement in good faith, and it's certainly a barrier to generating trust between the different levels of government.
You got something to add, Mr. Carpenter?
I just think one is in danger of dancing on the head of a pin, because I don't think it's right to, as a matter of law, to regard sort of Clause 11 as anything in the way of a power grab. You have to look at the Scotland Act as a whole to determine whether competence has been devolved or not. And indeed, there's an interesting remark by Lord Hope in Imperial Tobacco case. He said that the fact that Section 29 provides a mechanism for determining whether a provision of an Act of the Scottish Parliament is outside rather than inside competence does not create a presumption in favour of competence. So in other words, you look at the whole of the Act. And so I think it is right as a matter of law that these powers are not sort of latent and subsisting in Scotland. They were never conferred on Scotland. So I think the power grab language doesn't really help. And also I think Professor Page has shown that this is actually quite a small problem because so many areas are in fact reserved in any event.
As you said before.
It is quite a small problem. As often with politics, things are more apparent than real, and presentation is all.
Cheryl Gillan.
I'm just taking on a bit. I mean, obviously, with what Professor Page said about Clause 11 causing difficulty in identifying what devolved legislatures have competency over makes it extraordinarily difficult. How might this impact evil English votes for English laws? And what additional layer of complexity could be overlaid on the process?
Shall I?
Yeah.
I used to do evil in my time. Actually, Whitehall is not allowed to talk about evil. It's not a term that must be used. It's English votes, I think. Well, yes, of course it would. I mean, it is quite difficult at the moment, but then we do it, and we've undertaken to this, in my former incarnation, I undertook to the Speaker that we will not take a chance on this. If there is any suggestion that the tests would not, unless it was the clearest possible case, we would not advise him to certify a bill. And in that case, you would just fall back to the normal parliamentary procedure. I mean, it would add an extra layer of complexity, but the complexity would be dealt with by people, if I may say so, who kind of know what they're doing. So I wouldn't elevate that aspect of it really into a major issue. It will just be one of those things that one will have to deal with.
It's quite manageable, in your view.
I think it's manageable. Yes, I mean, it's burdensome, but we have managed it.
Can you give any sort of practical experiences of what has happened previously from implementing the existing devolution and evil frameworks? Have there been any problems?
Well, in the area that I'm most familiar with, which is legal affairs, in particular the civil law, the Scotland Act didn't really change very much because we already knew that since 1707 there was a union with a separate system of law. And as I said before, whenever international conventions are negotiated on choice of law, private international law arrangements, recognition, enforcement of judgments, Scotland always is closely consulted, sometimes on the Rome Convention on a law applicable to contractual regulations. The UK team was led by the Scots. So, as I say, there was a hand-in-glove cooperation, just based on, I think, shared respect and understanding of our two systems. I mean, every lawyer, if he's properly trained, knows that there are significant differences in Scotland, less so in Northern Ireland, and you'd have to go back before the 16th century for Wales, but there are differences emerging.
Anything to add, Professor McEwan? No, it's fine. Thank you.
Moving on, Ronnie Cowan.
So I was going to ask you about Professor Alan Page's standstill agreement, but we seem to have covered that quite eloquently so far. So I would refer to Professor Rick Rawlings, who told us that if the competences come back first to UK government, Whitehall departments will find it convenient to hang on to these powers rather than to pass them on. How can we address that?
But I have no way of knowing whether that's the case or not.
We are.
Yes. I mean, I think to accept that the sequencing intentions, if that's what they were, will not hold. So to accept that this is something that has to be dealt with in tandem the issue of where competences lie when on exit day and in the immediate aftermath, I think has to be considered alongside the broader issues. If I can perhaps just add something to what you were saying there with respect to English votes for English laws, there are, of course, similar difficulties and challenges that will face the presiding officers in the devolved legislatures from, if Clause 11 stands as drafted, from understanding what is in fact within their competence after Brexit and that's partly to do with the ambiguity around this body of law that we are calling retained EU law, and also the fact that that's not static. Retained EU law, because of the modification powers that are there, and it's not clear to me what will happen in the future, whether that will gradually be replaced by primary legislation or not, but because that is in any case an inherently ambiguous body of law in terms of the boundaries of it, knowing when devolved legislation falls wholly within competence or may be in some parts beyond the competence will be extraordinarily difficult for the presiding officers.
Are there changes that we could make to the face of this bill in order to achieve this? Yes. I mean, I think there can be some clarity provided to retained EU law in general that might help improve the bill for the whole of the UK. The point I was making specifically about the complexities for the devolved legislative process are entirely bound up with Clause 11 as it stands. I agree that it's a small problem, which also makes it one that should be relatively easy to address.
I think it's fair to say that the problem for those advising presiding officers in Scotland, Wales, Northern Ireland is more difficult than the one we face under evil, because they have to make a positive decision as to whether there is competence. Under evil, we don't give, if I could put it this way, we don't give those advocating an England-only procedure the benefit of the doubt. If there is doubt about competence, then the bill will not be certified. So it is easier. But as time goes by, this is one of the things that my former colleagues will certainly be discussing with their counterparts. Is, how do we avoid too great a sort of variation in how we interpret these things? Because naturally, sooner or later, we're going to both be dealing with the same question. Maybe not at the same time, but sometime. And it would make us look rather nonsensical if we're taking wildly different views as to the law.
As we are, we're 486 days from Brexit. Given what we can see coming in our direction and a feel of what will be devolved back up to Scotland, do the UK government and the devolved powers have the capacity to deal with these new powers?
You mean capacity within the civil service?
Yeah.
I think there will be capacity challenges for all governments. We already see that there are capacity challenges in dealing with the Brexit process as it stands. They will have to deal with it, I guess, is the short answer. I mean, in a sense, because the competences of the UK government will expand more considerably than the competences of the devolved governments, whatever happens to Clause 11, then the problems may actually be more acute within Whitehall than within the devolved. I suppose what I would say is that there is scope for engagement with outside expertise, an awful lot of opportunity to engage with the universities, for example, to help support policy development. A lot of that takes place anyway in a more informal and ad hoc basis, but I think there are more opportunities there.
I think one must remember also that it is not simply a case of member state governments just leaving the Commission in the driving seat just to get on with the particular policies. They have their own capacity to monitor and contribute to discussions in the council. So it is not going to be a totally new subjects they're going to come into. I suppose the one area that has caused concern is the negotiation of international trading agreements, because of exclusive external competence, the European Commission is in the driving seat, and the member states are merely observers. But they're still contributing to the directives or the mandates that are given to the Commission negotiators, but they're not actually doing the negotiations themselves. So to that extent, that will be new. But UK civil servants are doing negotiations all the time with third countries, so it's not going to be totally new. I think there will be strains in certain areas, but I think the service is pretty flexible in being able to reallocate people to deal with that. I can only speak for Whitehall, and that rather imperfectly.
There's already a tremendous strain on HMRC, and their job could change quite dramatically.
Yes, on VAT and
yeah.
stuff like that. Yes.
They're talking about £250 million and 3,000 new jobs, and that's just working towards the date. And there's still development and training, and does that worry you?
Well, the customs union stuff. I just don't know. My opinion is no better than anybody else's. It's not something I sort of lie awake at night worrying about.
What is me? Between North and Southern Ireland, we're going to build a wall now up here, apparently. Yeah,
that's yeah.
I should not on the computer anymore.
I'm giving you a little license.
And about time too.
Rupa.
I want to ask about re-regulation. I mean, stuff about this has been touched on, but it's quite a broad question. What are the main challenges for transferring or establishing UK common frameworks to replace EU common frameworks, and to also respect government systems in Scotland, Ireland, and Northern Ireland and Wales? Sounds like an essay question you accept your students.
Let's start with Professor McEwan, and then Michael can pick up the legal points.
And I guess I don't want to rehash things that we've already said. My understanding is that at the moment, and Secretary of State certainly confirmed this, that what they are trying to do just now is sort out the process for agreeing common frameworks. The content they anticipate will be dealt with further down the line.
Out of the structure.
So the process for reaching agreement. One of the biggest challenges around the process will be that issue of what happens when you can't agree, and what happens when disputes emerge. Now, I don't have a ready-made answer to that. I think perhaps we can look to some of the experiences that have worked, more or less, and try to learn from those. And I'm thinking specifically of the Joint Exchequer Committees that were bilateral committees between the UK government and the Scottish government in the first instance. Now, there'd be different views as to whether or not that worked. It was certainly very intense, and it got to an agreement in the end. Perhaps a fudge, but it got there. And that has built within it its own process for dispute resolution should such a dispute emerge. Now, we haven't had one yet within the context of the JEC, so we don't know how that would work in practice. But the process of the JEC with respect to Wales was much smoother than it had been with Scotland, because, in a sense, the Treasury learned how to engage bilaterally with devolved governments, and I think there was much more satisfaction all round with that particular process. So that was a learning of culture and practice of engaging with different governments. Thanks for the question.
Mr. Carpenter.
Much to add, but we don't have a clean slate here. I mean, we have the Active Union with Scotland and Active Union with England Acts, which set up a sort of internal market, if you like. Didn't use that language, but it was that sort of feeling, and that was reflected in the Scotland Act. And risk of repeating myself, a lot of these things will depend on cultures. As I say, in the legal area, I do not see any difficulty at all, because there never has been since 1700. Both sides readily accept the uniqueness and separateness of their systems, and to a lesser extent that's true of Northern Ireland and Wales, because it's just a given. But more broadly, it's just going. As I say, I don't think my opinion's worth any more than anybody else's on that, because who knows.
And then the second one is a kind of suggested framework structure one. It's been suggested to us that the legal and technical complexity of sorting out where returning power should rest should be considered by a standing commission, and the model that's been given is the Kenneth Cowan commission to do with the Scottish devolution that the last Labour government set up. Mm-hmm. What would you imagine, what are the pros and cons of taking such an approach?
Yes, if I may, I'll add one thing to your previous question around common frameworks, and I think one of the things that would be very helpful is to recognise that A, common frameworks won't always be necessary, and B, when they are necessary, they can take a variety of different forms. And we already have a whole body of concordats, memorandums of understanding in particular areas, on a smaller scale perhaps, but that seem to have worked quite well and can allow for divergence. Sometimes it may be necessary to have the legal underpinning, but it won't always be necessary to have that, and to still maintain the kind of degree of compatibility or uniformity perhaps that people may feel is required. On the issue of a standing commission, I think it's absolutely applaud the role of this committee and the others for engaging with expertise and feeding into the process, and I think that's where I think that is the best direction of travel. I think that this is the most appropriate forum for that sort of thing to take place, because I don't think it's just a technical issue, I think it's a political one. So a Kalman Commission or a Silk Commission or whatever can engage with a variety of different stakeholders, and it can engage with a variety of different expertise, and it can make recommendations, but ultimately these are matters of politics, matters of trust and respect, and I don't think a standing commission is going to resolve those particular issues.
Can I just press you a bit on that? Because the Clause 11 lacks any sense that there is a process to follow Clause 11. A standing commission with the right remit could make it clear that there is going to be a process that leads to decisions being made. Now, it can't predetermine the outcome of those decisions, but how else would you ensure that there is a sense that that Clause 11 is not a resting place, it's the start of a process that is consultative and consensual?
Yes, I mean, there is a process going on, but it's one that's very much between the executives, and it's very difficult for the rest of us to know exactly how that's unfolding. What I guess I would quite like to see is something to shadow that and perhaps maybe feed into it, and perhaps operate as a reference group for the different governments, an evidence base, if you like, to evaluate the competing claims that may be made.
So and it makes sense to you if this mechanism is somehow accountable. Is that what you're saying?
I think so. I think so, yes. And sometimes we are, in a sense, looking to the future, and you know, none of us have a privileged insight into that, but we can, you know, lend expertise to that process and help to inform the deliberation that's taking place between the governments. But I think my preference is for parliaments to be in control of that process rather than a separate committee of the great and the good.
Anybody else? Any further comment? I'm most grateful to our two witnesses. Thank you very, very much indeed. No doubt you will be watching the debates on days 4 and 5 with great interest. Thank you very much indeed.
You're welcome.
Order, order.